Hi, welcome to SGT University. I am Professor Sushil Manav from Faculty of Mass Communication and Media Technology. Today, we will be learning about the structure of judiciary in India. There are three pillars of democracy in India: legislature, executive and judiciary. Media is also often referred to as the fourth pillar or the fourth estate, but it is an unwritten status granted to the media. Today, we will be studying the judiciary and the structure of judiciary in India. Let's first of all go into the brief introduction of Indian judiciary. The judiciary is that branch of the government that interprets law, settles disputes, and administers justice to all its citizens. The judiciary is considered to be the watchdog of democracy and also the guardian of constitution. For democracy to function effectively, it is imperative to have an impartial and independent judiciary. Now, what does an independent Indian judiciary mean? It means 1. That the other branches of government, namely the executive and legislature, do not interfere with the judiciary's functioning. Number 2, the judiciary's decision is respected and not interfered by any other organ of the democracy. And 3, it also means that the judges can perform their duties without fear and favor. And also, independence of judiciary does not mean that the judiciary will function arbitrarily or without any accountability. The judiciary is accountable to the constitution of this country. Now we will go into the structure of Indian judiciary. India has a single integrated judicial system. The judiciary in India has a pyramidal structure with the Supreme Court at the top, high courts below the Supreme Court, and below them are the district and subordinate courts. The lower courts in India function under the direct superintendence of the higher courts. This diagram shows how this is pyramidal structure with Supreme Court on the top, but there is only one Supreme Court in the country. In the high courts are in the middle, there are 25 high courts, and lower courts, these are in all the districts of the country and also in the subdivisions. Now, there are two branches of legal system in India, which are, one is criminal law and other is civil law. Criminal law, these deal with committing of crime by any citizen or by any entity. A criminal case starts with local police filing a crime report, which we call FIR, and court finally decides the matter. And civil law deals with all disputes over the violation of fundamental rights of the citizens or any judicial legal rights of the citizens. Now, civil and criminal courts. Civil courts deal with civil cases. Civil law is referred to in almost all cases other than criminal cases. Criminal cases apply when a crime such as robbery, murder, arson, etc. is perpetrated. Civil law is applied in disputes when one person sues another person or another entity. Examples of civil cases include divorce, eviction, consumer problems, debt, and bankruptcy, etc. Judges in the civil courts and criminal courts have different kind of powers. While judges in criminal court can punish the convicted person by sending him or her to jail, a judge in the civil court can make the guilty pay fines, etc. District judges sitting in district courts and magistrates of second class and civil judge junior division are at the bottom of the judicial hierarchy in India. This complete diagram shows how the structure of courts exists in the country. Now, district and lower courts. Court of District Judge is the highest civil court in the district. It has both administrative as well as judicial powers. The Court of District Judge is at the district headquarters. The district court can try criminal and civil cases, and hence the judge is called district and sessions judge, because when this judge acts in civil cases, this judge is called district judge, but when it acts in criminal cases, the judge is called session judge. So the complete designation is district and session judge. Under the district courts, there are courts of sub-judges, additional sub-judges and municipal courts. Most civil cases are filed in the municipal courts, which is the lowest court in the subdivision. Now, regarding jurisdiction of the courts, there are 4 types of jurisdictions of civil courts. It can be related to the subject matter. So the subject matter jurisdiction is, it can try cases of a particular type and relates to a particular subject. The second type of jurisdiction is territorial jurisdiction. It can try cases within the geographical limits and not beyond that territory. Means, suppose there is a case related to Gurugram district. A client cannot go to the Judiciary district or Rohtak for that. The person has to go to the territory of Gurugram district only. Similarly, there is a pecuniary jurisdiction, means value, monetary value of the case. Cases related to money matters, suits of monetary value, this also decides the jurisdiction of a court. And fourth is the appellate jurisdiction, a case that has already been decided by the lower court. The Supreme Court and the High Courts have appellate jurisdiction to hear cases which were decided by the lower courts. Today we covered the topic of structure of judiciary in India, and in our next lecture we will be studying appointment of judges. Till then, keep learning, keep growing. See you next time.